Well, the breaking news at this hour, the SEBI board meet, which we were just telling you about, it has concluded. The first flash that we have is that it has approved the listing regulations. Remember, the market regulator wanted to convert the listing norms to listing regulations. Has also approved the insider trading regulations. And like we had told you, I'm going to ask my producer to pull out the definition that we had told you about the connected person, the new connected person, and the new insider person. That would, in a sense, mean that anyone who has been in contact with the company for 6 months, either fiduciary, in a corporate way, etc., would be deemed as an insider or a connected person, and such an insider would not be allowed and will be banned from trading in securities markets for at least 6 months prior to the concerned act in question, unless the person is, fulfilling legal obligations or just carrying out their duty. For the connected person, even the immediate family is going to be banned. So you're talking about siblings, parents, children over here. So these are the initial flashes that I have with me at the moment that I can tell you about. SEBI was also considering, when we're talking about the insider trading norms, for the first time to introduce an onus of proof, where it would be up to the connected person and the insider to prove that he or she was not in cognizance of the price sensitive information while carrying out the trades. We're going to try and connect you with our experts also at the moment, but this is of course the big story that we had been tracking. Something else that the insider trading norms had talked about was also it was going to clear out the defenses that would be available with a person to prove that they had not been guilty of insider trading. For example, if two promoters who carry out a transaction have the same price-sensitive information, or the person who is who has the knowledge of the price-sensitive information is actually different from the decision maker, the person who is actually carrying out the trade, that's perhaps going to be another difference that will, defense mechanism that will be provided to a person to prove that. So this is all the information I have with me at the moment. Something else that we were looking out for to see from, it has eased the delisting rules as well. We were just telling you about that. Something UK CINA, the market regulator, has talked about that he wants to introduce. First of all, to halve the delisting timeline from 137 days to 76 days. And the big one being that the stock exchanges would be asked to give their in-principle approval in 5 days and not the 30 days, which is the case as of now. More than that, perhaps we can also see a change in the reverse book building mechanism that is carried out, where the discovered price for delisting would be when a 90% threshold is included, which includes the promoter stake as well as the shares that have been tendered in by the public. Sajid also joining us. Sajid, we've been breaking all of these stories here on CNBC TV 18. Right now what we know is that SEBI has tightened the insider trading norms and eased the delisting norms.
That's right. The press release is just out on the SEBI website, and SEBI has gone ahead and made changes to the insider trading regulations. Among the various new norms would be that the connected persons, the onus of establishing that they were not in possession of a UPSI, which is unpublished sensitive information, shall be on the connected persons. Remember, the Justice Sodi Committee had put the onus on SEBI, and in the draft regulations which was floated in the agenda, SEBI had put the onus back to the connected persons there. There will be clear prohibition on communication of UPSI, and that this has been provided. So that all the connected people are under obligation to ensure that the information is not leaked. As we were talking about the definition of connected person, that connected person definition now will include all immediate family members and employees who are directors or promoters or key managerial employees. So these are some of the things which is part of the insider trading regulation part of it. Aside of that, there has been some amendments made to the delisting regulations there.
Sajid, we had also reported, something the Justice Sodi Committee had said, which had caused a lot of furor, was that public servant, is that term there in the SEBI press release? Because what we had picked up was that for the insider, it was not going to mention a public servant.
That's right. The regulations which we were discussing did not have the term public servant, and I think it continues as it is, because it just talks about people who have unpublished sensitive information, and does not say including public servants. So that continues as it is. There is other major.
And have they expanded? Have they expanded the scope of price-sensitive information, because that was also expected? M&As, demergers, expansion of business, listing agreements.
That has been brought in. Initial scope of insider information was only limited to certain functions or financial results of the company. That has been expanded, and now it has been also linked to the material information, which is now part of the listing regulations as well. So any information which is material in nature for a company is considered an insider information, and hence it has to be disclosed to the stock exchanges if required or not. But as far as the major key features of insider regulations are concerned, as far as connected persons are there, the scope of the connected person has been enlarged. Any person associated with a company directly or indirectly, there is no reference to the public servant here, but will be considered a connected person. Immediate relatives of connected persons shall be deemed to be connected persons, unless immediate relative establishes absence or access to the information. There will be some exceptions which have been provided, when in which cases immediate relative will not be seen as a connected person there. The definition of insider has been widened to include not only a person who is connected, but also to a person who is in possession of unpublished sensitive information. The onus of proof has now moved on to the connected person, as I was telling you. The Justice Sodi Committee.
And for the first time, in fact, Sajid, we're seeing the onus of proof being brought in. It is being introduced here. The onus is going to be on the connected person, on the insider, to actually prove that he or she was not aware or did not have that price-sensitive information while carrying out the trade. And this is also a departure, if I'm not mistaken, from the Justice Sodi recommendation, which had said it would be first up to SEBI to prove that, and then the connected person would have to say, no, I actually did not have the information.
That's right, and that's primarily based on a judgment of the, if I'm not wrong, Supreme Court, where the onus of establishing the proof was on the connected person and not on the regulator there. There is something called the generally available information. Now this information is should be available to public on a non-discriminatory basis, including research and analysis, and so the scope of information has been widened, so that now the research reports, the analysis of those reports are not now insider information as earlier it used to be. It's now generally available information there. All price material events are according to the listing agreement, which now has been amended to listing regulation there. The communication of due diligence, the access especially to unpublished information if the transaction may lead to open offer or in best interest of the company. That information can only be provided 2 days prior to the proposed transaction. This is something which has been deliberated by the Justice Sodi Committee as well, and it's been brought in here as well. The definition of trading will include dealing in securities. Now remember, earlier definition only spoke about trading in securities. Now dealing includes trading as well. So any transaction or any buying, selling, everything, they have widened the definition of the trading to include dealing as well. So anything which in whatever way you're going to deal is part of insider trading there. There are certain defenses which have been brought in, especially like trading plans. This is for prior information where the management or promoters who are planning to sell the information, if that information is brought to public notice, they will be allowed to sell the stake during a period when the material information, or there's a quiet period, the company is going through a quiet period. So as long as you have a clean plan in front of the compliance officer, you can go ahead with that. Disclosures.
If a trading plan and it's made public, then you can go ahead, otherwise you can't. Sajid, sorry to interrupt you there. We're also being now joined by an expert to discuss this a little more. He's just going to be joining us. So the other big change that I can see from the press is about to move away from the insider trading one, and this could be a huge one for the markets, and this is to do with the delisting, it being brought in line with the takeover code. So, you know, an acquirer now has to actually inform at the time of making an open offer if it wants to keep the company listed or delisted. That could be a huge one for the capital markets.
Sorry, Nanda, I didn't hear you that.
I was saying that if you were to look another way, if I were to move away from the insider trading and just bring your attention to the delisting one, a big change that is being proposed is that at the time, to streamline it with takeover code, and at the time of making an open offer, the acquirer now has to make it clear and disclose, is the company going to remain listed or is it going to be delisted? That's going to be a huge one for the capital market.
Yeah, and that's
M&As going forward.
Exactly, and that's going to be one of that was one of the expectation of many of the market intermediaries, merchant bankers who were looking at this kind of reform as far as delisting is concerned. If you look at delisting in particular, while there has been, they have brought in the issue angle of open offer at the time a mandatory offer is made. The company has the option to disclose whether it's going to be an open offer or a delisting at the time of a mandatory open offer. The issue of squeezing out of minority shareholders has still not been addressed by SEBI, and that's something which will be a thorn for many of the merchant bankers and many of the MNCs who are trying to delist from the country. But we have HP Ranina who is joining us today. Sir, you must have gone through. Must have got an idea of the insider trading regulations which has been approved by SEBI. Can you take us through what's your first thoughts about the insider trading regulations?
No, unfortunately, I've not been able to go through them, and therefore, if you can just tell me briefly what those regulations are, I'll be able to comment on it.
I'll just come in here. I'm Nantara. Thanks for joining us here. First of all, the definition of insider and connected person has been widened to actually go on to say that any immediate family member is going to be included, and any person on the basis of any contractual, fiduciary or employment relationship that allows such person to have access to unpublished price sensitive information. So you're seeing a widening of the information, and even if I may add, scope of the price sensitive information has been widened to include listing agreements, M&A activity, mergers, etc., business expansion, etc. So your first reaction on the definition and the scope being widened?
Yeah, I think that's a welcome sign because, most of the insider trading that was going on was due to people, though not strictly part of the company, but had access to a lot of information. For example, professionals, people who are, in any way connected with the company, of course, relatives and others. So I think this widening of the definition is a very good thing, and I think it is in line with international practice that you have to get, people who are access to information, because what is important is not your relationship. What is important is access to information. And if you have access to information, then you are an insider trader, though there may be no formal relationship between you and the company.
Mr. Rainin, I'm going to ask you to hang on there. I'm going across now to ASHWIN PAREKH from EY. Thanks, Mr. Parikh, for joining us here. You know, the SEBI press release also says that considering every investor's interest in securities market, advanced disclosure of price-sensitive information at least 2 days prior to trading has been made mandatory. What I want to ask you, is this standard procedure when we talk about developed stock markets?
Well, it is. Actually, the advance notice does become very important, so that the investors are not taken, for a last-minute kind of an announcement. So, I mean, it's very welcome. It is in keeping with the international regulations. Whether it is 2 days or otherwise, it's a matter of detail. I mean, see, with communication systems expanding, with a lot of digital information data kind of spread, I think 2 days is a very, very good approach, I would say.
Mr. Rainina, you're the lawyer, so I'm going to come to you now. What SEBI has also introduced is the concept of onus of proof, where it's going to be up to the insider and the connected person to prove that he or she was not, did not have the price-sensitive information while carrying out the trade. How is this going to work? How do you see this panning out?
Well, burden of proof, of course, is a very important concept and can be the subject matter of a lot of litigation. But the principle behind it is correct, that if somebody has to discharge the burden that he was not aware of the information at the time when he traded in those shares, now that is something which may be difficult to establish in a court of law, but I think this is a normal procedure which is followed, where somebody has traded in the shares, he has been in some way or the other privy to some information, and then he has made a profit out of it. Therefore, he has to show that he was not privy to any information when he traded in those shares. So that again is a procedure which will be subject to a lot of litigation, and of course it's a very dicey issue. But I think all over the world, this issue of burden of proof has always been there.
Okay, and that is a concept that's now being introduced in India.
Yes.
Mr. Parikh, if I can now come to you, we're also seeing delisting norms being simplified considerably. First of all, the timeline being halved from 176 days to 37 days. Also, we're going to see a change in the reverse book building process, where SEBI says the discovered price shall be that at which the shareholding of the promoter, after including the shareholding of the public shareholders that have tendered their shares, reaches a threshold of 90%. How significant do you think this is, a new way of reaching the discovered price?
Yeah, I mean, both the elements are very important. I mean, there was almost, a requirement from the corporates, I mean, from the industry, that these two measures be included, particularly in the delisting norms. So one is very glad. I mean, both these were being discussed. One was the timeline, and the second was the 90% mark. So very welcome, I would say, very welcome. SEBI has really responded to the market requirements, I would say.
Mr. Parikh, in the delisting amendments, even though there has been some movement as far as bringing clarity of open offer or delisting offer at the time of mandatory open offer, the SEBI hasn't actually, addressed the issue of squeezing out of minority shareholders once you cross the 90% mark, and that would be something which will be a big concern for many of the corporates who are trying to delist from the country, because that has been a long drawn process for squeezing out of minority shareholders.
Yeah, now that's the point is, can we have a reform or can we have a policy as far as that aspect is concerned? It does become very difficult to establish whether the minority interest, arising out of the situation of delisting to the extent that, I mean, it's between 90 and 100%, whether that can be protected, that can be, I mean, SEBI can go all out and provide some kind of a protection measure to that. To my mind, it's a little difficult. I think we'll have to leave it on a case-to-case basis, and then minority, if they establish that there has been any, let's say, loss of value or whatever, then I suppose on a case-to-case basis it can be handled. But for a policy kind of, I would say 90% mark is a good mark. I mean, we do agree that, therefore, those, I mean, in the minority will have to really, I mean, they may suffer on account of, let's say, such a measure. But in the larger interest of, let's say, the market requirement, I mean, I would say for the time being, unless, of course, we come across so many cases where the minority shareholders have a point to establish on any value, let's say, reduction or dramatic value reduction on their part.
SEBI has also worked on the timeline for delisting approvals. They have tried to crunch the timeline from 137 days to nearly 76, basically halving the entire delisting timeline. They're also talking about, stock exchanges will now have to give a principal approval within 5 days as against 30 days earlier, and they will have to look at the data of top 25 shareholders for the last 2 years process before giving the approval. Do you think this the entire process will bring in some kind of transparency in terms of a timeline when a delisting offer can go through? Because many times price is one of the factors why a delisting offers succeed or fail.
True. I mean, see, basically, there are two aspects to this. One is, I mean, if you look at the entire thing from price discovery point of view, then there's an excellent measure. I mean, there's a very welcome measure. I mean, one is to see how even the reduced timeline, how does it really work for the entities. But let's look at the entire situation from the entity and the merchant bankers, the investment bankers point of view. Let's say to hold on to that transaction at that particular price for a longer period, does become very difficult. So, I mean, I'm glad that the timeline has been reduced. I mean, this is a requirement once again from the market, and the market has been asking for it for quite a while, I would say.
Mr. Parekh, I think the big reason the timeline is going to be reduced is because stock exchanges are going to be asked to give their in-principle approval in 5 days as opposed to the current practice of 30 days. The other thing I want to talk to you about is to do with the takeover regulations. The SEBI press release says option to the acquirer to delist the shares of the company directly through delisting regulations pursuant to triggering takeover regulations has been provided. However, the delisting attempt fails, the acquirer would be required to complete the mandatory open offer process under the takeover regulations and pay interest at 10% for the delayed open offer. So from what I understand is the acquirer will have to decide beforehand, going to be listed, going to stay at the company listed, is it going to be delisted? What do you think of this measure?
Yeah, I mean, two parts. One is, let's say in the normal course, you cannot really take an escape route, through the delisting part and then go back, to the investor. So that's one part. The second is during that interim period, the investor's protection to the extent of that 10% price is a measure. I mean, at this point in time. Once again, on a case-to-case basis, we will see. But, the escape route had to be blocked, I mean, quite clearly. And that's something that has been very well done over here, I would say.
My sources tell me that SEBI had received feedback from all kinds of stakeholders when it comes to delisting, that there was a fear and there were cases of perhaps promoters acting in concert when it came to promoters parking of shares, etc. So what SEBI has now said is that a promoter group shall be prohibited from making a delisting offer if any entity belonging to the said group has sold shares of the company for a period 6 months prior to the board meeting in which it was decided to go in for delisting. Is this enough to ensure that we don't see promoters parking shares, that minority shareholders' interests are protected, that promoters don't act in concert?
Yeah, see, I mean, based on the past experience, based on the actual cases, the regulator has observed that this was one of the approaches, that the promoters were carrying out. At least they have, put some amount of a control on that. Going forward, if there are some more malpractices which may be observed, or practices which in some form do not protect the interest of the minority shareholders, then we might come across more measures or more clarification of this one. But I think for the time being, from whatever we've seen, in the past, this looks to me like a very good measure, as a first very good step towards controlling that part.
ASHWIN, the SEBI is also trying to review the entire regulations or restrictions which are imposed on willful defaulters. The entire there will be a review of the entire policy. Currently, they follow what the guidelines have been issued by Reserve Bank of India, which basically prevents them from raising public issue or rights issue for any willful defaulter. Now, this definition of willful default or restriction is expected to be expanded because there are many ways now a willful defaulter can come to the capital market and raise funds. What is your opinion on it? Because this is just going to be a policy frame, a discussion paper which will be released, and SEBI will eventually take a decision on it based on feedback which it gets from the public.
Yeah, I mean, this is one of those measures which is arising out of the coordination between the financial sector regulators. I mean, RBI had mooted this particular reform, and it's a very welcome one. So once any one of the two, either the market regulator, and in this particular case, or in many cases, we may have banking regulator, I mean, the banking system, announcing a borrower as a willful defaulter, then in that case, all routes of that promoter or that defaulter accessing public funds should be stopped. not just through the banking system, but also through the capital market route. So either by way of equity issuance or by way of debt issuance. It's a very welcome measure. It's something which is really essential. So which means automatically one of the two regulators, when he announces any borrower a defaulter or any issuer a defaulter, then in that case, the other regulator must also step in and make sure that public funds are not made available to such borrower or such promoters. Very welcome measure, I would say. Let us study the paper.
Why do you think that they didn't go ahead? Mr. Parekh, why do you think that they didn't go ahead and then actually impose those restrictions? Why is it going in for the path of actually having a discussion paper to discuss the pros and cons? Because as of now, nothing stops a willful defaulter from having a rights issue or a public issue.
Yeah, see, basically, technicalities in terms of what does the existing law, let's say, allow the regulators to do such an act. So the paper, I'm sure, would be pointing out, some of the difficulties in the current legal framework on one side, and must be also discussing, I'm sure, at the same time, some of the other measures which are essential to make sure that then such a practice can be actually introduced. But to my mind, at least, let's study the paper and let's study the difficulties, the pros and the cons that SEBI is referring to. But in the longer run, if the financial regulators, that the finance sector regulators work in coordination, then borrowers may find or promoters may find difficult to access public funds and then not remain answerable or accountable for that,
The other discussion paper that we're going to see coming out from SEBI has to do with reclassification of promoter stake as public stake. I think one of the big concerns have been that, post an open offer or a separation agreement between promoters, we actually see the outgoing promoter entity still being used to meet the minimum 25% public float norm. So what are the changes or the amendments that you would want to see as far as this goes?
Yeah, see, once again, it boils down to, the same question. How much of public fund is actually either through the banking system or through the capital, in this particular case, it's capital markets route, is accessed by the promoters. And then by way of various measures, including, transfer of shareholding, including, either merger and acquisition activities, whether there is a masking of or there is an approach not to repay, any kind of either interest or dividend or, the capital back to the investors, any such measure, which takes away the public funding has to be curbed. So to that extent, let's study the paper, but to my mind, we can't really allow public funds either from the banking system or from the capital markets to be taken away by the promoters and misapplied or misused.
Mr. Parekh, I'm going to ask you to hang in there. Mr. H.P. Rainina joining us back here on CNBC TV 18. Mr. Rainina, what I was discussing with Mr. Parekh was about willful defaulters and the reclassification of promoter stake as public stake. What SEBI has decided to do is come out with a discussion paper on all of this, especially with the willful defaulter. If I could begin with that, to discuss the pros and cons, and if willful defaulters should be restricted from being allowed to do rights issues and public issues, as is the case at the moment. Your thoughts on that?
No, certainly if there's a willful defaulter, he has to be barred from accessing the market or from trading. That goes without saying. But the whole issue is who is a willful defaulter. You must be a defaulter and it must be done willfully. So that is a definition which will have to be tested in a court of law, and that will depend on the facts of each case. But if it is proved that the person is a willful defaulter, then I think the consequences of that have to be accepted, and they have to be harsh. Because anybody who indulges in this activity has to be punished. He can't go.
RBI has already come out with a master circular on willful defaulters, explaining that, also restricting bank financing to them. So isn't that already there, or is that still a grey area? Is that what you're saying?
No, it's not a grey area. What is a grey area is the definition of willful defaulter, because that will depend on the facts of each case. But things like, I don't want to name anybody, but obviously if people have been defaulting and we've not been paying banks, then he has to be deprived of future funds. Because otherwise, you can't use public funds to finance, ventures which are not properly managed and or which people have been accused of, siphoning out. So willful defaulter consequences are correct. The only issue is that you can't pinpoint who exactly would fall within the definition, because that would depend on the facts of each case.
Mr. Ranina, there's some minor changes which have been done as far as settlement of cases, especially in terms of administrative and civil proceedings are there. Currently, the settlement was allowed after a show cause notice was issued to the concerned party. Now, there has been some minor tweaking where SEBI is now allowing for settlement prior to a show cause notice being sent to the party. Is this a good move? Because will it reduce the number of days or the timeline for settlement of a case?
Yes, I think it would certainly reduce the time frame and make it easier for people to come forward for settlement of cases, because generally settlement means somebody coming forward voluntarily. In every provision of law, settlement of cases comes in where there is a voluntary disclosure before the person is found guilty or before there is any proceedings initiated against him. And therefore, if you issue a show cause notice, then obviously the authority is aware of the possible default. And settlement of cases, therefore, is always, encouraged for people to come out voluntarily before the default is detected. And therefore, this provision, I think, is the correct one.
Mr. Rainina, Mr. Parekh, hang in there. We're now joined by Mr. Sandeep Parekh. Thanks for joining us on CNBC TV 18. This is Nayantara. Sandeep, we're seeing more stringent norms come out for insider trading. And if you've been watching CNBC TV 18, you would already know what the widened definition of insider is. But I'll tell you what it is. It's by including persons connected on the basis of being in any contractual, fiduciary or employment relationship that allows such persons access to unpublished price-sensitive information. It also includes immediate family. The scope of price-sensitive information also being widened to include M&As, financial results, business expansion plans. Your initial reactions to all of this?
My initial reaction is all these changes, the so-called widening of the insider trading regulations is actually a misnomer. It's more of a clarification in terms of, these kind of people, for instance, relatives and contractual, contractual people, they're always part. Anybody who had in fact access to information would be covered. So I think there is some little bit of expansion, no doubt, but it's mainly clarificatory, brings in more kind of,
you mean it plugs in the loopholes that perhaps existed till now? You mean it just plugs the loopholes? The other thing I wanted to ask you was that as far as, no trading will be allowed unless the price-sensitive information is made public 2 days prior to the trade. Is that in norm with global practice? Is that how it's done in the developed markets?
No, that's not the norm. So we have, in fact, I think we've pushed it towards transparency, more transparency than the global standard. So which is a pretty interesting development. I don't know if it's going to be welcomed or not welcomed by the industry, but it is somewhat unusual in the stringency and transparency of the disclosure prior to the trade. So it's
Mr. Parekh, you talk a lot about one of your pet topics, one you like to talk a lot about, is a takeover code. When we talk about delisting, there is a thought process of streamlining that with the takeover code, where an acquirer may have to announce beforehand that the company is going to remain listed, is going to remain delisted, will have to offer the open offer price in case the delisting fails. What do you make of all of these changes?
So I have not seen what changes they made to harmonize the takeover. Earlier, of course, there used to be a yo-yo effect, which is if you acquire X number of shares, you have to make an open offer. Then once you make an open offer, you breach the minimum public shareholding. Then you bring it down again, and then you do the delisting. So this increase and reduction of shares was obviously an aberration. So I'm not sure they've cleared that up, because I very quickly looked at the press release. But if they have, that's, I think, it's a very positive sign.
But Sandeep, Sajid here, even though the disclosure has to be made at the time of mandatory open offer, whether you want to make an open offer or go for a delisting, there is still the clause there that in case your delisting fails, you will still have to go back to the open offer with the open offer price with an interest there. Is that the right move going forward?
Yeah, no, so it's a good move. You continue with the open offer, and if you breach the higher norm, then you go ahead. You're permitted to go ahead with the delisting, so that yo-yo effect goes away. So I think it's net positive, and I think it's quite pointless to really ask somebody to increase shares, then reduce shares, and then again increase shares for the delisting. So this one-stage process is good for everyone.
And what about the squeezing out of minority shareholders is concerned, because that's something which hasn't been tackled by SEBI. The New Companies Act also is very is silent on that aspect of squeezing out of minority shareholders. That still remains a concern for many of the bankers and many of the foreign companies who wish to to delist from the Indian markets.
No, so I think it's. I think this is a relatively optimal space, really. I think squeeze out would have a major investor backlash, because then you're essentially saying that I'm going to compulsorily buy your shares at what I consider to be a fair price, and if I'm the owner of shares, even if it's a fair price, I may not want to sell. So I think that it's kind of expropriation of a shareholder's rights. So I think that would face with very substantial shareholder outrage. So SEBI has kind of rightly not gone in that direction. But of course, corporate India wanted that. So it's I don't see that happening in India anytime in the future. But of course, a few people have gone under the Companies Act and achieved that through other means.
Sandeep, I remember when the draft regulations of insider trading came out, you had some reservation as far as due diligence is concerned. There is the provision there that you can share unpublished price sensitive information with a third party if you think that the transaction is going to be beneficial for the company, or it will lead to an open offer, and this disclosure has to be made only two days prior to the announcement of transaction. What is your view on that? Because there has been a lot of debate about this due diligence part as well.
Yeah. No, so again, from what I read quickly from the press release, they seem to have legitimized due diligence transactions. So they've cleared a large number of transactions which are beneficial for the company. And what was really happening till today was that private equity or the other institutional investors, before investing in a company, they would do a due diligence, and they used to be very scared because they were given access to price sensitive information which was not in public domain, and therefore they were technically kind of in violation of insider trading norms. So I think giving those people protection would actually be beneficial for company shareholders and for the institutional and private equity investors into these companies. It will give them a lot of comfort, and I think that's a big positive.
There has been a lot of changes which has been made to the listing regulation as well, Sandeep. From a listing agreement, SEBI has moved into a listing regulation where they have come out with certain material events, and that's a big list of material events which needs to be disclosed to the stock exchange. And now SEBI says that it has to be done on an e-platform rather than doing it physically to the stock exchange. What's your view on that? Because the concept of material is also well debated. What exactly constitutes materiality? And here SEBI is saying that anything which is material, and the definition is much wider, will have to be disclosed to the stock exchanges.
So I think it's fair enough. I mean, material standards are worldwide. I think we have common definition, really. I mean, what is material is something which would be relevant in making an investment decision to a reasonable investor, is kind of the broad, common law understanding of what is material. And the material is exactly the same thing as price sensitive, so something which will have an impact on the price itself. So I think clarifying it is of course useful, but at the end of the day, I think it has to be more principle based and not kind of rule based approach. So in principle, if investors would find that kind of useful bit of information, that is material, and I think they may have kind of clarified it further with more examples and stuff. But so I think that's a good thing, and of course converting the agreement into regulations will give SEBI more flexibility in enforcing it. So I think that's another kind of change which has been brought about.
Right. Thanks, Sandeep, for joining us here with your reactions on what all the SEBI board has decided. So you have more stringent insider norms, but Sandeep Parekh saying perhaps not so much more stringent as it is of plugging the loopholes, at least as far as the definition of insider and connected person goes. Delisting norms definitely being simplified, timeline being halved, a new book building process is what you're seeing, it being harmonized with the takeover regulations as well. We're going to step into a short break. We haven't taken one in a long time. Stay tuned.